Good afternoon and welcome to the November edition of the Divorce Support Club with me, Claire Macklin. I'm a breakup and divorce coach and I work alongside Walker Family Law to provide an additional service to the Simply Legal. We offer a safe, informal place for you to gather information, ask questions, and gather a toolkit to help you navigate your way through your separation or divorce. So today I'm joined by Natasha Alsop from Walker Family Law. Natasha, would you like to briefly introduce yourself for us, please?
Yes, thanks, Claire. I'm Natasha Alsop. I'm a solicitor here in the Family Department of Divorce and Finances and Children. So that's my kind of special area. And yes, I've been qualified now for over 20 years, and I team lead our team in Devon of our lovely paralegals and other solicitors.
Thank you very much, Natasha. So today we're going to talk about when it might be necessary to go to court through your divorce and how you can perhaps best prepare for that. So I know from talking to clients over the last decade or so that most feel really scared or terrified, even some say, of the divorce court process. They're afraid, they're confused about the cost, they're anxious about what actually happens in the courtroom. So I hope that today my plan essentially is to ask Natasha as many of the questions that I get asked all the time as possible, and cover as much as we can in relation to what court covers, what it's like to go there, and to give you clarity about when you might actually need to use the process. So first of all, could you explain, Natasha, how often do divorce cases actually end up in front of a judge and in court? And what are some of the reasons for that?
All right. So I probably ought to just distinguish. So when people say we're going to go to court, there's often the case that we're going to court informally, if you like. So we're saying to the judge we've reached an agreement and we want a judge to look at it, and we do that through kind of an online process. So that's we're not going to be talking about that area as such, but what people may understand as going to court is, if I actually physically have to go, or if it's online or on Teams, if I have to be before a judge because there's a reason why we've needed a judge to assist, as opposed to what you would know when you apply for a divorce, which is still going to court, but you're doing it online. You're doing it on a paper based, if you like, and you don't actually have to have any interaction with the court other than uploading an email document. So yes, so the reasons you might go to court could be in relation to any aspect of your separation. That might be if you're going through divorce proceedings and you've been unable to resolve, for example, finances arising from your marriage, and therefore looking at some remedy within divorce proceedings. It may well be that you have to go to court in respect of your children because you just can't agree, or there may be emergency remedy that you need. So, for example, someone might need an injunction. We normally call that ordinarily you'll be doing that in respect of a partner or spouse, and that's what we call a non-molestation order, or you might need occupation of the home. So there's all sorts of types of cases. And then the reasons you may well go, well, there's all sorts of reasons, Claire. I'm sure you have clients say to you, look, actually, I don't know what to do. For example, I've tried and I've tried and I've tried, and my husband or wife is just not doing anything, and I don't know what to do about this. And I think that my solicitor is now saying, look, we might have to go to court and ask the judge to help us. There's that. It might be simply that that you've started to get information from your spouse, for example, but you're concerned that it's not all there, and you might want the judge to help with that by the court ordering disclosure of a certain document, or some order is needed from a third party, and you can only really get that by going through the court process. Or just generally not being able to agree. I mean, it might be that one person isn't engaging, but it's just that you've been trying and trying and trying, and it's now, months down the line, and you think, we just can't agree this, and someone else is going to have to adjudicate for us. And in those circumstances, it would be the court, it would be a judge. Are those the kind of reasons that you see why people say, oh, I think we're going to have to, ask the court to help us now?
Yes, absolutely. And I think the important word that you've used there, you've used it a few times, is help. The court is there to help you as opposed to anything else. It's trying to help you resolve any of the issues that you might have. Um, I think that the thing that often comes across when I'm talking to clients is that um, they're scared of the whole process of going to court. And I just wondered, is going to court always a bad thing? I don't think it always is, but perhaps you could explain how sometimes taking your case to court might actually be a really helpful, productive step to take.
Particularly in finances, yeah, particularly in finances, Claire. So I think, sometimes they can drag on, and that's often what people say, isn't it? I've been waiting now months for this to be resolved, and it still hasn't
Mm.
been resolved because we're just not quite getting there. And with finances, we often look at it as a proactive step, particularly between solicitors. If you've both got solicitors and we're discussing matters between us, we might say it might actually help to have what we call a court timetable. So in financial matters, the court will issue directions at the start and say, this is what you all need to do. So someone will apply to the court and say, we might need the court's help, as I say, we might need to refer it to a judge. But initially they'll do what's called directions, so things for you all to go off and do. And you get then a timetable. So the parties then have, you must give your financial information by this date. You must go off and find out how much you might be able to borrow on a mortgage, how much a lender will give you. And it gives you a shopping list of things to do. So it focuses everyone's minds and you're doing it on the same timetable. So it to some extent, that's a positive thing. I know
Yes,
people don't always see that, but it actually says, okay, look, we're not actually, it's drifting a bit here. How can we make it a bit more focused? And to do that by having a timetable for both parties, it can actually help you to resolve it in a quicker. I say quicker. There are still delays in the courts, but it can actually just say, well, at least we know what timetable we're working to. In the next couple of months, we're doing this. Then the next month, we're doing that, rather than it just being left
yeah,
uncertain. So, yeah, and actually, I think sometimes it can be a positive step. Obviously the courts don't really want you to refer it to them unnecessarily, but
mm,
if it's not, if it's only going to, if you're not going to be able to settle it obviously very quickly, so if you have something come in and you say actually this might need court intervention, then why not look at it sooner rather than later and not fear doing it? Because I think some people feel
yes,
fearful of what that process
yeah.
costs, times, emotions will look like for them.
Yes, and I mean, I've seen it sometimes where that one of the people, either the husband or the wife, is just not engaging for whatever reason that is. They're not engaging in the process. And as you say, sometimes putting in an application can give some deadlines that then those people need to meet. And of course, I think what lots of people don't always understand as well is that at any point you can stay the court process
Mm.
in order to negotiate again or take your case to mediation or um, go to some of the other things that can run alongside the court process. So that might be really helpful for people as well to understand what kind of other processes can kind of run alongside a court process. So let's say you've put in your application and you've got a date for a hearing. Um, what can be going on in the background in the run up to that?
Both family and children, both divorce and children. So any family case really that's not an emergency case when you need injunctive
Mm.
relief, you would be hopefully looking at all sorts of kind of settlement options outside of the court process. So
Mm.
whilst a court is unlikely to just say, well, you've put your application in, we're just going to leave it for a year, and see how you get on. They wouldn't kind of stay it for that long. But if what they will do is look at something called non-court dispute resolution. So outside of court dispute resolution, what kind of other alternatives are there? So what we call
Mm.
ADR. So the judge will want to know before each hearing what the parties are doing, and they will encourage you both to look at all sorts of other options. So there's mediation. You might want to go off in finances to a private FDR judge by saying, actually, we've started the court process here. We've got all the information I have now got through the directions that the court's made, and we now have to look at settlement, and we actually think that it would be really helpful to have an indication
Mm.
from a private FDR judge. So what that means is, instead of going through the court process at that point, the parties can say, actually, we'd like to appoint someone that they both agree, separate from the court. So it might be a barrister or a solicitor who is doing private FDRs, and they can almost, I wouldn't say, the process is much more kind of open with flexibility for the parties to agree what that might look like. So they can agree the timetable for that. They can agree, will it be a half day a day? Will it be by teams? Will it be remote, or will it be in person? What kind of information does that judge need before? And they can be kind of more interactive to some extent in the run up. And some clients really like that process. It's often quicker as well. So yes, you may well get to the stage, and it's important to kind of understand this, that once you're in the court process, it's not that you have to follow it all the way through to the end. For various reasons, most cases will never get to that end point, because either they'll agree a settlement, or they may well go off and use a different process in the meantime, for example, a private FDR judge, which helps with the process. Or they may say, actually, now we've got this information, we're in a better place to go off to mediation. So, judge, can you please give us 3 months to do that? And it's very likely that the court will say yes, as long as it's looking like, both parties are signing up to that and willing to do that, because they both have to consent to that, and they can go off. So it's not, once you've made your application, it doesn't mean to say that you're just kind of on that one road and you can't turn off in a
Yes.
different direction. You can, and there's definitely flexibility now for the court to consider that, and they encourage it. They encourage any kind of alternative dispute resolution that parties can look at, because ultimately they want you to be able to agree yourselves if possible. Ideally a judge doesn't want to say, we've got to make the decision for you, but some cases, and I would say only a very small handful of cases, even when we issue, will get to the stage where they're right at the very end, where they say, judge, we need you to make the decision for us. 9 times out of 10, even once those proceedings are issued, they will still settle in another way.
Yes, that makes complete sense. I think it's really important that people hear that, because there is such a lot of fear about starting that process. I've heard it described, my clients talking to me, describe it as pressing the nuclear button. It's seen as something really explosive to do. And what I'm hearing here is it needn't necessarily be, and there can be other things going along alongside it, which hopefully will end up in lots of those cases coming out of the court system again.
Exactly.
And I know that the courts don't want all these cases in there, because they've got so many cases that they're really grateful always when a case comes out of their system.
They are,
about, go on.
They are. I mean, that is true. I mean, our starting point is always to when someone comes in to see myself or any of my colleagues here, our starting point will always be to look at all the possible solutions and look at it from a problem solving perspective to see whether there's any way we can sort this out without, we don't really want to refer it to the court. That's the first, but sometimes it just does actually help. And sometimes it's inevitable for other reasons. So you may well say, look, this person hasn't now responded for 3 months, the other person won't engage at all, and you have no option. And when you're in that situation, for example, I mean, you might have an example, for example, where, a husband may be in the home, wife's moved out of the home, and perhaps wife is earning more money and contributing to the mortgage, for example, and says, look, actually, I thought we were doing this whilst we were trying to sort everything out, and how long can I carry on doing this? And it might be that the person in the home has then batten down the hatches, if you like, and you just can't get any response at all. And that is kind of, then you've got a stalemate. What do you do in that position? You've tried everything you can think of, to try and get the other person to engage. And the alternative to court is not attractive either. Someone might say, well, if this carries on, I'm going to stop contributing. I'm not going to pay anymore. And that's not an attractive option for anyone, particularly if there's children. It might result in increased debt. Potentially, it's going to be more acrimonious then between them than if you'd referred it to the court in the first place. So it's not always kind of I think the fear that court proceedings is going to escalate everything. If you
Yeah.
approach it in the right way, so if both solicitors are on board and they say, actually, we're doing this for this reason, and both parties can understand that, it's not necessarily a kind of aggressive step. And actually, we'd always try and avoid it being that
Yeah.
step anyway. But you can approach it, and it's the way in which you approach it. You often say that to Claire, didn't you? It's not that something's going to happen, it's how you
Yeah.
think about it and approach it and your mindset
Absolutely.
towards
Yeah.
it, don't you? When we've had these
Yeah, it's not
chats
what's happening.
before.
It's not what's happening that makes the difference. It's actually how you approach it and how you're communicating about it and how you're talking about it and how you're thinking about it that makes all the difference. I want to come back briefly as well to where you've got somebody who's not engaging in the process, like you were just talking about in the particular example that you used. I think it's worth just highlighting that, I mean, people that I work with can make all kinds of assumptions about why the other person might not be engaging with the process. Um, and there could be all sorts of reasons underneath that. It's very frustrating when the other person is not engaging in the process and you want to push it along or you want to, to get to an agreement and come to a result. And I always say to my clients, try and stand in the other person's shoes and let's think about what might be triggering them not to respond. Now, sometimes it might be because they are exerting some kind of control, they're being coercive. It might also be because they are afraid. It might also be because perhaps they are the weaker financial party and they are perhaps in the house and things are okay as they are, and there's not really much incentive to sort of push it along. And it might be the other way around. It might be that they're the stronger financial party and they're reluctant to reach an agreement because that will mean sort of sharing their pension or whatever it might be. But I always think it's worth looking at what the emotional triggers are behind what people are doing and trying not to jump to assumptions too quickly about what the reasoning behind it might be. I don't know if you've seen sort of other things going on as well. You've probably seen all sorts of situations where what one person perceives as happening is potentially not quite exactly what is happening.
Yeah, I think that's often the case, and it's very difficult to look behind that and see behind
Mm,
that, particularly if someone's kind of shut off
yeah,
communication and becomes very closed. It's quite difficult for either us as an advisor or the person involved to know, and that's really
mm,
difficult. But it can come out in the process.
yeah,
Once you've reached an agreement, you will, or you've got to the stage where you're at proceedings, and they are engaging. You have emails that don't really relate to what the issue is currently, and which you can then understand much more.
mm,
The stance that they took a few months ago, it becomes clear, but it
yeah,
doesn't always become clear, but it can do. And you think, oh, well, that's why they weren't
mm,
really engaging. Um,
yeah. The
but
other
it
thing I
can be
always
really
say is,
frustrating for people, can't
yeah,
it? Just
oh,
feeling
it
that
so
I
can.
just need to get this done, because they come to us when by the time
Mm,
they've come to us, they've kind of decided that they want to do something and they have to take action.
mm,
And it can be so frustrating for someone to feel, I'm trying to take action, but now I'm just in, waiting and waiting and don't know what the future holds for me. And it's that
mm,
kind of not knowing
yeah,
how it's going to end for them whilst
mm,
waiting and on the other
yes,
person to
yeah.
respond.
And I think that's true, especially in situations where actually the person who's waiting and the person who's wanting to have some movement on it and the person, the other person who's not engaging sometimes is the person who's kind of initiated the process as well, which
Yeah.
is even more frustrating. But what I always say to my clients is, whatever the reason is, it's not about you. It's about something that's happening for the other person. Because sometimes people find themselves. I remember working with one client who her husband wasn't engaging in the process at all. And she had interpreted that as his view of her as being worthless um, and not worth responding to, if you like. And once she'd realised, this probably wasn't about her at all. It was about whatever fear it was that he had, whatever need it was that he had. Um, it enabled her to move forward in quite a different way. So I think it's always worth sort of stepping into the other person's shoes and having a think about why they might be behaving in the way that they are.
Yeah,
Um,
no, definitely.
yeah.
That's a good point,
Um,
Claire.
so moving on, I think that the other thing I think always is, don't listen to those people around you who might have had a really terrible experience through the divorce courts. Um, it isn't always like that. I was talking to somebody only this morning who had had some advice from somebody that they knew and who had been through an awful, a really, really acrimonious, terrible divorce. And actually, the advice that she had given would potentially have lit a fire in this particular situation. So just be really careful about the advice that you take, and who you're taking it from. So I've talked to people who know what they're talking about, I think, rather than are speaking from their own experience, perhaps.
Yeah, no, I
Um,
agree with that, definitely, Claire.
yeah. So let's move on to perhaps to some sort of things, some practicalities and things.
Mm.
So one of the biggest fears, of course, is how much is going to court going to cost. So
Mm.
is there are you able in any way to put a number on that? Probably not.
Probably not. It's so variable depending on whether it's children, injunction, finances. It's very, very difficult. What we do though, and actually our rates are quite different. You might have a barrister involved, just solicitors. This is probably something to just kind of explain now that
Mm,
sometimes you will not always have your own solicitor doing your court hearing. I do as much of my own court hearings as I can, but inevitably you might have two on the same day, or you might be on holiday, or you might not be available. And you might have to have, it might be a colleague from the firm, or you may well instruct a barrister who's someone who just goes to court for people instead of kind of sees you in the office on a day-to-day basis. You're instructing them to do your advocacy for you. So that's important, first of all, for people to understand. And then the costs associated with that is that you're having to pay for someone else to go along with you on that day, so you've got that cost, as well as preparing your day-to-day work in the office, preparing for that hearing. So inevitably costs will increase. We do try and do a breakdown for each hearing. So for example, in finances, if you're getting divorced, I'll use that as an example, and you just can't reach an agreement and you say, right, we've got to go to court, you have three main hearings in finances. So you have a directions appointment, first directions to say, right, judge, let's look at everything and see what we've got and what else we might need. Then we have a resolution appointment. Can we get this settled? And the judge helpfully looks at all the papers and gives the parties an indication of what they would do if it was before them on a contested basis. And that's the bit that you can go off to a private FDR judge. And then you have the end hearing if you can't agree at all, and the judge will finally make a decision, and you have a kind of more kind of comprehensive court hearing. So depending on when you settle, or if you have to go all the way to the end, will dictate how much cost you spend. You may well, and I think this is probably a misconception in terms of people thinking it will cost an absolute fortune. If you do that first process to the first directions appointment, sometimes you'll save money by getting a court timetable and doing it. Then you will continually writing, chasing for disclosure, going through something
yeah.
called voluntary disclosure, where you do it voluntarily and then nothing's happened again for 3 or 6 months and you have to update it all and do it again. So
Yes.
actually it can be, you might spend a few £1,000s getting to court and you're there, but you're at least there. So
Yeah.
it can actually be more cost effective in finances to get to that first
Mm.
stage. It's
I've
really difficult
certainly,
to kind of put a number on it, but you're not
yeah.
looking significant amounts. It does depend on the case. I mean,
Mm,
these are three main hearings, and if you've got very complex cases, you might have a number of other hearings because
mm,
there might be issues with assets abroad. There might be interim maintenance needed. You might have someone might say, look, I'm completely cut off financially, so we have to issue proceedings, and then we have to ask the judge to list another urgent hearing to get some kind of maintenance in the meantime. So it really, really does depend on the case. They are all so different, but it's
mm.
not, it's often not as kind of awful as it might seem.
Yeah.
And I think you're quite right. You hear from friends, and a few matters may well give the whole process a bad give it a bad
Yeah.
reputation. And actually, you're just worth asking your solicitor. You're both to each your solicitor. Look, can you give me a breakdown of it? I know you can't tell me exactly, but each process. So to get to
Mm,
this hearing, can you then let me know how much it's going to be to go to the next hearing? And each process say, right, this is the next steps. How much is it likely to cost me to go to that hearing?
yeah.
Because that's going to affect how you settle and whether you do
Mm.
settle.
I think there's something that I noticed just now, and I've certainly worked with clients who have spent a long time with correspondence going backwards and forwards, trying to get disclosure, for example, of assets and so on, um, and spending an awful lot of money in that process, and then having to go through the initial court process as well, to get that timetable in place. And sometimes I think, if they had gone straight to that from the beginning, then yes, they probably would have saved costs. And there's also another cost in this, I think, which is sometimes the emotional cost of the protracted nature of trying to get somebody to engage in the process sometimes is very overwhelming. And that I think there's an emotional cost to factor into some of the decision making on this. And I guess that can work both ways because sometimes let's imagine, for example, that the reason one person isn't engaging with the process is because they're still in the sort of very early stages of denial, that they're in shock still, that they don't want this to happen, and they haven't quite got their head around that this even needs to happen. Then sometimes if you bring some compassion into that, you might slow things down a little. And then there are other cases where somebody's just digging their heels in, for example, or using, refusal to disclose as a control mechanism, where the emotional um, impact on the other person is so high that it's worth pressing that button. So I think what I'm saying is every case is very, very different. All cases are about really, they're human things, aren't they? They're about the humans involved in them. And I don't know about you, but I've never worked with two clients who've been in the same situation and behaved the same and acted the same. I've never had two conversations in sessions that have been the same. So
No.
it's a very human process, this, outside of just the legal paperwork. It's a really human process. And I think that needs to be taken into account, which is, of course, why we've
Yeah.
got these sessions as a
Family law
part of
is, isn't
that.
it? Particularly,
Yeah.
it's very, there's a lot of emotions involved. So, well,
Mm,
some more than others, children involved often. So
mm,
there are, it's not, and it is discretionary, that whilst, we've been through all this in other support club discussions that we've had, but you can't say to someone, as you may well do in other areas, this is exactly what I think the court will do because it's right or wrong. It doesn't really work like that in family law. Every case is so case specific, and it's at the
yeah.
discretion of that judge that's going to be looking at it. So there are risks associated with going to court, and then you have to balance that against the cost. But any good, any advisor who is experienced
Mm,
enough to, said, look, I've done this amount of cases, I can say to you, this is the risk that you're looking at in carrying on
mm,
in that way as opposed to settling in this way. It will be able to advise you on that and whether it's worth pursuing the cost, because actually what court is always looking at, and if you end up in court proceedings, you will often hear this phrase, is it necessary, is it proportionate, what you're asking me for. So someone may well say, look, we've been through the negotiation process, but I think that I'm going to use an example of, I think my husband had an account 20 years ago and he hasn't disclosed it. I'm not sure whether he still got it. And I think there was a transaction, 15 years ago that,
yes.
you might have had money from a family member or friend. And it's quite clear that that money's not still there. The court's not going to order that. So we know that it's not necessary and it's not proportionate to go to court and ask a judge just for that reason that we need to issue proceedings. So
Mm,
as long as you've got an advisor, or you can, have anyone advising you who knows the process, they will let you know whether it is actually worth going to court for some of the issues which can feel quite significant to the person, but the court won't necessarily see it the same way.
yes. Yes. I think I was speaking to somebody just very recently. The court is not the court is not there to sort out fault and blame, and and indeed the law was changed, of course, a couple of years ago to recognise that. So the court is simply looking, if we're talking about finances, is simply looking to make a fair split. It's not actually looking particularly at, it's not going to look at behaviour unless it passes a particular
Mm.
threshold, is it? So
No, exactly.
yeah, and I think that's really difficult sometimes for people to really understand that actually the court is not, it's not going to take sides as it were.
No,
I think
no,
that's
no,
really
no,
useful for people.
no, it won't. And it's courts are there to find solutions, just as we are
Mm,
as advisors. They're looking at
yeah,
solutions rather than you will hear that from judges frequently when you go to court. They will say, look, the person in front of them will often want someone to listen to what's happened. That's really important to them. They want to share their story of what's happened, and clients want to tell us what's happened because that's what's important to them at the time. And a judge will often say, well, actually, you need to look forward because we need to look at how we're going to resolve this, really.
yeah,
And my job is I will take all that on board, but the judge ultimately is going to make a decision for you going forward. It's not necessarily going to look back. And something that's really important, I know we'll probably come on to this in a minute, and I might be maybe it's already when you are in a hearing, it is actually the court's got limited time to deal with the matter. So
mm,
you don't have a week or you don't have 3 days, depending on the case. And that's something which I don't know if you've had clients say this to you before, but that's something that I find I have to explain to clients quite a few times because they obviously don't want to feel shortchanged. They've now asked the court
yeah,
for assistance and they want the court to know everything. They want the judge to know everything possible. But our job is to siphon out what we think is likely to be relevant for the judge. And also, even once we've done that, the judges do have limited court time. You pay your court fee and you go off to the judge and say, right, this is what we need to do. And the judge might say, well, I think that's going to be a day in court. And a day isn't actually that long by the time you've made
mm,
your arguments both sides, and then you might have to listen to what one party's got to say, and then someone else might listen to the other party, and you ask them questions. That will go quite quickly. So
mm,
you you shouldn't go into the court process thinking they're just going to listen to everything that's happened over my life or our lives, because you
yeah,
will feel shortchanged if that's the case. So it's important to understand that kind of you're
mm,
having to really condense it all down and give the court a real
yes,
summary of everything that's happened. So that shouldn't be a reason to go to court if you think, well, I want to go to court because I want the other person and the judge to hear everything that's happened, because that probably
mm.
won't actually
No,
happen unless it's a specific type of hearing. We have like fact
yeah,
finding hearings in children proceedings or something. There are hearings where that will be very relevant, but if we're looking at, say, finances, there will be limited time to go into everything if it's not likely to affect the outcome, so if it's not really
yeah.
relevant to the issue in hand.
I guess that's kind of the different. It's the division between the legal paperwork process and the financial division of asset process, and then the emotional
Yeah,
process that all
exactly.
run, all run side by side and concurrently through this process. And I think, that's really the understanding of that has, I think, shifted in the last 10, 15, 20 years of um, the impact of all of those three things on each other through this. And I think, it's really important for people to recognize that the emotional process, let's deal with that, try and deal with that outside of the courtroom.
Yeah,
Because,
so then
you
you
know,
can get the points as concise as
yeah,
possible. So the judge having to
exactly.
decide for you or assist you in terms of a financial dispute resolution is kind of the FDR process. They're assisting you. Finally, they're going to make a decision if they can't. But if you can
Mm,
condense that down, you're going to get the most out of that process.
yeah.
And the other thing to remember is kind of coming back to what we said earlier. If you feel if you don't pay extra for each hearing in terms of the court's fee, so you pay a court fee at the start, which isn't very much, a few £100. You pay that, and then that's it. You don't spend. The court doesn't charge you exactly for
Mm,
each, any additional, process, other than if you have to make an application. There might be in between. There might be a fee for, I need to ask the judge to extend this. There might be a fee if that's agreed or otherwise, but it's very nominal. You're
mm,
paying for your solicitor to be there, or if you're going on your own, you won't, but you're not paying for that court process along the way, each hearing. So if funds do allow, and you wanted to go down that process that we talked about earlier, which is a kind of private financial
mm,
dispute resolution hearing. So you say to the judge, could you pause that a minute? We're going to go off and do this process, and you do have funds. And you both say, look, we think that it's really important for the judge to spend more time than they could at court, and we want to fund that ourselves. You could do that. So you have the
mm,
flexibility to do that. You could go to a private FDR judge, a barrister, and say, we want to
yeah.
look at this for 2 or 3 days, because we feel that if we only had a day or a day and a half at court, we wouldn't be able to get all our points across as
Mm.
much as we'd like to, and you both agree, and that's what you want to do, and you have the money to
Yes.
do that, you
Yeah.
can pay
Yeah.
that judge, because that's what you're doing then. You're paying for that actual hearing.
Yeah. Yeah. That
Um,
makes complete sense.
and if we say, look, we think it's going to be 2 days, whereas the court might only give us 1 day, and they can, that's another option. But that is
Yeah.
fund splitting, and it does mean, you're paying for a process which you would otherwise have, without any cost to you if it's through the
Mm.
court system, save because you're still paying for your representatives.
Yes. Yeah. No, that totally makes sense. I think, well, one of the other things that people often ask about is what actually happens. What does the courtroom look like?
Yeah,
We see, and I think we see things on television, and I think clients often think that they're going into something where the judge is going to have on, a wig and a gavel and all of those kinds of things, like in a criminal court. So can you describe just briefly, what does the courtroom look like? What can people
yeah.
expect?
So the actual court building will vary from town to town, city to city, where they're so different. Some are just what we call county courts, county and family courts, so they are dealing with civil matters. Other courts will be combined, so they may be in the magistrates' court dealing with magistrates dealing with criminal matters, and that's also in the same court building as then the civil matters, so family. Or it might be, for example, in Exeter. I'll give Exeter as an example there. You will go along to the family court, but that's also the Crown Court. It's quite a big
Mm,
kind of building, which would look to anyone looking at it as a traditional court building where you
yeah.
have criminal trials as well as a family matter. So that can probably, I imagine, to people look quite daunting.
Mm,
You look at this big court building, but actually in family matters, it's quite informal, really, particularly on those smaller hearings running up to a hearing, but they're generally in private in what we call chambers. So it's
mm.
a big meeting room and you have a
Right.
judge on sitting there on one side, and
Not wearing a wig.
you are not wearing a wig. No, I mean, they're generally, and they're not in their joggers. They normally are looking smart, but yeah, no, it's a very different, I think, phrase. I mean, it's hard to know what people have in their minds, but I think you're right. I think some of my clients do assume that it will be, they assume that they will be walking into a courtroom like they see in
Mm,
terms of criminal jury trials,
yeah. And then it
which are
feels like,
quite intimidating, and we'll have
yeah.
to go and give evidence all the way over there, and is there going to be, and very occasionally you have to go in a hearing like that, but it's unusual, very unusual. Most of
Mm,
it will feel quite informal to them. um
yes. Yeah. That's really good. And I think Um, I remember there being a video on there's a I'll
there
see if
is,
I can find the link to this. There's a video, isn't there, on YouTube where you can, is it Stephen Wildblood who
yeah,
did
that's
it?
right, yeah,
You can watch what a hearing might look like. So if we can find a link to that, that would probably be really helpful. If we
yeah,
can
we can do
find
that.
that
And
and pop it in the comments.
the court website as well, because I think it's, some people haven't seen, there are occasions when if you're doing children or divorce, whichever, divorce and finances, whatever area you're doing, someone might not have seen their partner since they separated, and
Yeah.
that's actually quite common. They
Mm,
might have been on email, but particularly if they haven't had children, or they don't still have young children, so they don't need handovers or anything, they might find they've had no reason to see each
mm,
other in person. And the first time they actually see each other physically is when you go to court. I'm sure you've had people talk to you
mm.
about that, haven't you, Claire? And that can, I think, be quite daunting
Yes.
for some people.
Yeah.
So they might feel, even going to the court beforehand, if someone feels, oh, I'm actually really worried about this, I haven't seen my wife or my husband, for 18 months now, and the first time I'm going to see them, and I don't know where you're going to be. Where are you going to be? Are you going to be in the
Mm,
car park? Are you going to be upstairs? And they might want to just go and visit the court if they,
yeah.
it might, if they are concerned about it, they might say, well, actually, I'd rather just, you know, go and have a look and see what the
Yeah.
building looks like, so I can prepare myself. I don't know if you had people say that to you, that,
Yeah,
yeah.
I've advised people to do that as well in the
Have
past
you?
because
Yeah.
and I think where that can be really helpful is that you can then prepare some of your emotional preparation for going to court can be running through the day in your mind. And if you've got somewhere and you can imagine yourself in that corridor and you can see where the loos are and you can see what the room looks like, it's easier then to imagine that day going forward. And I do have some visualization exercises with clients around walking through in their imagination the day seeing themselves behaving as they want to, seeing themselves, um, you know, staying calm and successfully representing themselves and coming out the other end, having done it. That's quite a powerful thing to do because your memory and your imagination kind of fire the same circuit. So if you can go into that courtroom having already visualized yourself doing it successfully, your brain doesn't really know the difference between your memory and your imagination. It thinks you've already done it and will feel more
Yeah,
confident.
that's interesting. Yeah.
Yeah. So I think it's really useful to go and see where it is you're going to be. And you can also then plan, you'll know where the toilets are. And I often help clients create some little rituals that they go and do in front of the mirror in the loo to prepare themselves. There might be stretching rituals or saying something to themselves in the mirror or holding their hands high in a kind of power pose and things like that just to help them go into court feeling a little bit more confident. So yeah, I think it's really
And
good
don't,
to go
and
and
also don't be afraid of asking your solicitor that, whoever your representative is, might be a friend or it might be
mm,
a solicitor or a legal executive or whatever, but don't be afraid of saying to them, look, would you mind if we met outside? I've had clients say that. I think as solicitors, probably we are at fault sometimes because we're there all the time. You forget
yeah,
that actually it can be quite daunting. Just say, oh, well, I'll meet you at court, and this might be the client's first time there. And I think it's
yeah,
natural for us too to
yeah.
forget that can be quite an anxious process for someone. So if don't be afraid to say to them, look, actually, would you mind if we met? I've been there, or I know, is there somewhere outside we can meet, and I can
Mm,
go in with you because
yeah.
don't know,
I
I
think
feel
it
more
can
confident
be,
to do that, and that's fine too. So it
yes,
doesn't have to be.
it can be really daunting to not know where you're going to meet your representative, and it can become then the thing that you really worry about, which actually can
Yeah,
then distract you from doing your preparation, making sure you know your numbers and all of those things. Um, so
that's
yeah.
a reminder for me. I think. I think when I go to court, you're kind of that you do forget, I have to say, because you're busy
Mm,
preparing the case and thinking about all the legal aspects, that it can be easy that you can forget that actually it is quite daunting for someone. And
yeah.
then they also, I think what's important, I do try and remind clients of this before we go. As solicitors, we're there all the time. We know the process, and often what will happen is, you'll chat to your client, and then most of the discussions might happen away from your client when you're negotiating. So, say you've got two solicitors there, and you are negotiating. That might then happen away from there, and that can become. The client can think, where is my solicitor gone? She's gone 20 minutes, 25 minutes, and you're
Mm,
busy in another room with the other barrister or solicitor trying to negotiate a settlement or trying to get your client's view across.
yeah.
So you should expect that because that will happen.
Mm,
Your representative will not just sit there for the hour because they are there. You'll generally go an hour before, so you can have what we call pre-hearing discussions, and that will involve them being without. You won't be in those discussions necessarily if you've got a representative there doing that for you. They're going off to kind of convey your case and what you're looking for, and so there will be a period of time when you're on your own. So you can bring a friend if you want. You can come on your own, or you can bring a friend, or bring a book to sit and read if you think you're going to be
mm,
waiting, rather than just prepare for the fact that you might have periods where you are
yeah.
sat alone. I think that's
Yes.
probably, it's not a legal point, but I think that's probably something that I think clients say, oh, I didn't realise you were going to be gone so long. And
Yes. Yeah. I think the
that's
other thing, one of the other things that has come up when I've been talking to clients after hearings and so on, is that sometimes there are delays and things don't quite happen when they're supposed to, and all this kind of stuff. But if you're there in person,
yeah,
take some water, take a packet of biscuits, take
yeah,
some things to help keep your blood sugar high because you're going to need the energy and so on. I
yeah.
think there's just one more thing that I wanted to very briefly touch on, and I think it's worth saying we had a session a few months ago with Becky Barnes, who's a stylist,
Oh
and she
yeah, we
talked
did.
about
You and I
yeah,
did,
it
didn't
was
we?
you,
Yeah,
wasn't it?
yeah, it was you and I.
She talked about what to wear and how what you're
Yeah.
wearing can impact on how you're feeling and so on. So, could you just give us a very brief idea of what does the court expect in terms of what you should wear or what your options are to wear when you're going to court? Because I have had clients who really worry about this. And
Yeah,
I always
you're
advise
quite
them,
right.
have your clothes set out ready. But then the next
Yeah.
question is, well, what do I wear? What's the court
Actually,
expect?
that's probably the number one question I often get asked before hearing. What
Mm,
am I supposed to wear? And
mm,
I would say, I mean, there's no dress code as such we have a dress code as representatives that we have to kind of follow, but there's no dress code for anyone attending court. But what I would say, and the advice that I would give to a client is try and, dress as smart as you can for you, essentially. So you don't have to wear a suit. If you wear a suit for your day job and you're quite comfortable, then yes, but don't wear a suit if it's not something which you feel comfortable. Don't try and dress as something that's going to make you uncomfortable all day just because you feel like I'm going to court, I should. Just a reminder really to be kind of as kind of smart as you can for what if you look and say, well, that's what I would wear, instead of, I don't think, you want to feel comfortable, but making sure you take your coat off and things like that. I've been in hearings where a judge just said, because a client's got their duffel coat on and hasn't taken it off yet because they don't want to take their coat off. And I think just those little things actually. So I would say kind of smartish, but only within what makes you feel comfortable. Does that?
Yes. Yeah, no, totally makes sense. And one of the other things that I talk about sometimes with clients is having something that's hidden that no one else can see, but it's there. So kind of, I remember one client who sewed a little red ribbon into the hem of her skirt. It's just something that you can touch, which which can kind of take you back to a place where you feel a bit more confident, or it can remind you of something that is going to help you get into the right mindset and those kinds of things. That's the kind of work that I often do with clients, kind of behind the scenes. So I think that,
That's it.
Natasha, is probably all we have time for today.
I know.
I think
I've been talking too
so
much
much
today,
more.
Claire.
No,
I know. I could talk about this topic a lot because it feels that it does. Yeah, it's a lot of our day. So thinking
and
about
I think,
whether we have to go to court or not.
yeah, and actually, it's for our clients who do end up having to go to court. It becomes it's a very big thing, and it becomes for some people a very defining experience. So I think it's important that we recognise that, and you know, and understand just how big a thing it is for many of our
Yeah.
clients to go through. So,
And just as I said at the start, really, to remind anyone listening or who might listen to this, is just that that's not the aim when you start out. If we can, we want to look at every other possible solution than having to
yes,
go to court, because that's what everyone ideally wants. It's just that if it does have to happen, we can frame it in a slightly different way. But ultimately, we try and avoid it if we can, because everyone would prefer to make their own decisions and not have someone make it for them if they can.
yes, absolutely. Thank you, Natasha,
All
for
right.
sharing all your expertise
Yeah, it's
today.
good to speak to you, Claire.
No, really good. And we will be back next month. So thank you
Yeah.
very
What have you
much.
got
And
next month, Claire? Do you know yet? Or should
oh,
I not? Oh, sorry, I put you on the
I
spot.
can't. Yeah, I
No, you
can't
can't
quite
remember
remember.
off the top. Yeah. That's
But the
okay.
emails will come out
Yeah.
to
Okay.
tell people what it's all about. And also watch out for if you go onto the website, you can see little snippets, kind of sort of snippets of advice that have come from these sessions. So make sure that you do that. And also, the other thing I was going to say was there are a few other webinars that we've done in the past, which would probably be really helpful for people in this situation. So we've done, there are other webinars around emotional preparation for court but also for meetings and so on. You and I did another one, I think, about do I have to go to court maybe a year or two ago,
Yeah.
which covered some very different material to this one. We've got other ones about how to handle very challenging ex-partners. And of course, we have a special one that we did with Karen Clipping around the family courts and domestic abuse, which I'm very aware, we haven't really touched on today, but we had a
Yeah.
specific
I
session
was
on that.
thinking about talking about that today because there's all sorts of other things that would
Mm,
relate to that in relation to the court process, but it's kind of within the time period. It probably, in a
it's
way, it could
impossible.
probably do with its own
Yeah,
chat, really, Claire, because there's lots of other procedures that are put in place for when you go
yeah,
to court if there's domestic abuse. So I didn't
yeah,
touch on that today, but it deserves its own half an
yes,
hour, I think, of
yeah,
discussion.
yeah, something to put on
That's
our
quite a
list.
different story. We're not assuming that that's the case in what we've been
Yeah,
talking about today.
yeah, absolutely.
All right.
Brilliant. Thank you ever so much, Natasha.
Thank you.
Take care, and I'll see you soon.
Thank you.